This morning on the Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
Well, let's talk about a couple of recent articles that you have on two separate topics that you put up on your blog, and we'll talk about where you can find that here in just a second. One is on family settlement agreements for farm families that are not done properly, and this goes to a recent case in Iowa as well. But laying the groundwork on that, let me ask, what is a family settlement agreement, and how does it work, and how can it be useful for farm families?
Well, it definitely is one possible method of how you can resolve conflicts among family members concerning a number of things, and that could include your assets, how they're going to flow to the next generation, your finances, and a whole host of other things when we talk about farm and ranch operations. And there's a right way to do these, and sometimes, unfortunately, things go awry. But if they're done properly, it can outline the duties and responsibilities that family members have, and hopefully minimize or eliminate future family disputes. But it is a legally binding and enforceable contract, so we have to give some thought as to how these things are structured and what the goals of the family would be when they try to enter into a family settlement agreement. And definitely before it's entered into, the family has to carefully consider the purpose and scope of the agreement and what they're trying to accomplish. And the problems that need to be addressed in the agreement should lead to provisions drafted into the agreement that are designed to resolve those problems. So it can be a very useful document, but sometimes things go wrong.
Well, and you mentioned that, and we talked about or teased, I guess, the case, the recent case in Iowa involving a farm family that ended up, just reading it, looks like an absolute mess on a proposed family settlement agreement. So what happened in that case?
Yeah, mess is, I think, the good technical term to describe what happened here. Here you had mom and dad. They were longtime farmers. This is up in northeast Iowa, so people want to put in their minds, this is some of the really prime farm ground in America, let alone Iowa, but really prime farm ground. They had farms in 3 different counties, lots of land, and a multi-million-dollar estate. Dad died in 2001. Mom died in 2019. So mom outlived dad by a number of years. And they divided the farmland equally between them in value and then executed what we call mirror image wills back in 1998. Now, that's a very common estate planning technique when the exemption was much lower than it currently is. At that point in time, it was less than $1 million. I think it was $625,000 in 1998. And so what you would do is you would divide the wealth generally equally in terms of value between mom and dad by retitling assets. So in this instance, farmland, trying to get the farmland titled in a way, some of it owned individually by dad, some of it owned individually by mom, so that it didn't matter who died first. We could still have mirror will provisions. The will said the same thing and left the property in the opposite direction depending upon who died first, with a remainder down to the kids. And so that's what they did, and that made a lot of sense in 1998. And they had 4 children, 3 of which were daughters, 1 son. That 1 son farmed with his dad, and he continued to farm on his own after his dad died in 2001. Now, here's where it gets a little sticky. In 2003, and we have to watch this kind of stuff as practitioners going on and make sure we have our antennae up to make sure there's no monkey business going on. But 2 years after dad died, the farming son went with his mom to see her attorney, and she changed her will as a result of that conference to divide the farmland into specific farms and distribute them among her 4 children. 4 farms totaling 420 acres went to the son. 3 farms totaling 151 acres went to the 3 daughters to share equally. So look what happened, Greg. Mom and dad had an estate plan that split basically everything equally between the kids. After dad dies, 2 years later, son takes mom to the attorney. He ends up with, in her estate plan, being drafted so that he gets 4 farms totaling 420 acres, and his sisters split 151 acres between them, so about 50 acres each. And then there was one farm with 230 acres to be divided equally between all of them. So the son comes out way ahead on this. And some would say, well, he's the farming son. Mom's probably doing something else to benefit the daughters. This thing gets even more twisted because that 2003 will named the son and one daughter as executors of the estate, but he didn't tell his sister about that. Only the son knew that. Plus, Mom named her son and a different daughter as agents under a power of attorney, and again, the daughter didn't know that. She was not told of that designation, and the son told his other sister that she no longer needed to help their mom with her finances and bills. So you see something fishy going on here, and about the same time, when you add all of that together, Mom entered into a 16-year farm lease with the son with rent set at $70 per acre. Now, keep in mind, this is prime farmland. You can be guaranteed, even in 1998, the fair rent was probably more than $70 per acre.
So was it this? I'm curious now. Was it the sisters that discovered the mother's amended will?
Yeah, 11 years later, in 2014, and all of the children then and their mom met with an attorney to have the 1998 will restored, which left everything equally to the 4 kids. Well, here's where I think, I can't tell for sure, but I certainly wouldn't have done it this way. The attorney met with Mom privately, determined that she didn't have the capacity to change her 2003 will, so she's locked into that. So he suggests a family settlement agreement as an alternative. Okay, but what happened here was Mom and the 4 children enter into a family settlement agreement that divides all the mom's property equally among them upon her death. That's like a will. You don't use a family settlement agreement in that fashion. You do it if you have disputes after a death to try to clean things up in an amicable way among the family members. And then the attorney didn't have, if that's not bad enough, the attorney didn't have Mom sign the family settlement agreement, and 2 of the 4 siblings died before Mom did, including the son. So you got an absolute mess here, and that leaves it up to the courts to sort this whole thing out.
So what did the courts, throughout all this, what did the courts end up saying?
Well, bottom line, when we went from the trial court on to the appellate court, is that the family settlement agreement was not valid. The party's interest, as the court said, had not yet vested because Mom was still alive at the time that the agreement was entered into, and 2 of her children predeceased her. And their children, the predeceased children, were not party to the family settlement agreement, which is a requirement of Iowa law, and it'd be the same thing in Kansas. And so the siblings, what we call an expectancy interest, passed to the kids, but they hadn't signed the children of the children, the grandchildren, but they hadn't signed the family settlement agreement at the time it was admitted to probate. And so that was no good. And there were some other issues that were involved, but this was a totally incorrect way to use a family settlement agreement.
So throughout all this, just listening to that, what is your perspective, or what is the take-home of what you see here, and how a farm family can approach this properly?
Yeah, well, we've got multiple things that were tied into this one. One, if you have capacity issues, testamentary capacity issues, you really can't have that person enter into a family settlement agreement. Now, I know the attorney tried to finesse it by not having Mom sign it, which there would have been problems with that. But what was cast in stone in 2003 was cast in stone. What they needed to do in this instance was, especially because there were children of predeceased Mom, wait until Mom's death, and then if the remaining surviving siblings can't sort things out in accordance, and if there's disagreements with the way the 2003 will left things to the survivors, then that is the point in time when you try to do a family settlement agreement or you do mediation. That's why we have an entity such as the Kansas Ag Mediation Service that's run through K-State to help in these types of situations. This one was just done horribly incorrectly, and it was a bad result for the farm family all the way around.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, we go into the next case we're going to talk about. This has to do with the rights of co-tenants and adverse possession of minerals. In this recent case, looking at, again, setting up an estate plan on whether it is beneficial to leave assets in co-equal ownership to the children. Let's go back to the children once again. So let me ask, isn't it common for farmland to be left equally to the children, and what problems might that create?
Well, yeah, it is. And if we put ourselves in the position of many parents, the desire is to benefit all their children equally. I want to be fair to my children. I can't tell you how many times I've heard that. But that's a concept that we've tried to disabuse farm parents from, particularly if they want to see the operation continue into the next generation. Fair does not mean equal. Equal does not mean fair. You may have on-farm heirs, you may have off-farm heirs. The on-farm heirs want control of the operation. They want ownership of the land. The off-farm heirs want money. And so if you just simply divide all the land up equally and have, if you have 4 children, say you have 4 co-owned, 4 individuals that own all the farmland in co-ownership and an equal undivided interest in the entire thing, chances are that's not going to last very long into the next generation. The off-farm heirs view that as a dead asset. They want to get their money out of that, so they can force a partition and eventually have the land sold and the cash proceeds split, and then you've got a mess. You've got nobody that's happy in that instance. Particularly the on-farm heirs are not happy. So that's a bad thing to do. And it also can raise another issue. I see this fairly common. I get a half a dozen, I suppose, questions on this every year just from Kansas, and that is the land went to multiple children in co-equal ownership, and there's a tenant on the land, and you got one child that doesn't like that tenant, wants to terminate the lease, and the other 2 don't have any problems with the tenant, and they don't agree with their sibling. They want the lease to continue. So the question is, can the 1/3 owner, who has a co-equal ownership in the entire thing, but it's a 1/3 undivided interest, terminate the lease without the consent of the 2/3 majority? And that's kind of what was at issue in this recent case out of Illinois involving mineral rights.
And let's get a little further into it. Kind of break down what we saw in this recent case in Illinois.
Yeah, real quick. You had a couple of trusts here due to various estate planning strategies that ended up as co-tenants of farmland. And the trustee of one trust that had a 50% interest in the mineral estate in farmland claimed that it acquired the other trust 50% interest in the mineral estate by adverse possession. So that's one issue that's out there. I'll come back to that in a moment because the courts really didn't address that in this case. And there were counterclaims back and forth. There's a title company that gets involved, and the question basically is, in a nutshell, was whether a 50% co-owner can remove and sell the minerals without permission of the co-tenant. So you've got 2 50% owners. Can one of them say, well, I'm going to go ahead and improve the minerals. I want to remove and sell the minerals, and I don't need your permission. So that's what it boiled down to in this one. And the court said, well, we've got a procedure in Illinois that has to be followed if the 150% owner doesn't give permission. And that procedure needed to be followed in this instance. Now, that is a state law specific issue there, and that's going to vary from state to state. But, Greg, it shows you, again, a unique issue of a problem that comes up when we leave farmland co-equally to our kids. And you might have a mineral estate that's involved, like we had in this case from the southern part of Illinois where they have mineral interests. The court did not address the adverse possession issue. Now, the appellate court sent it back to the trial court on remand to clean up some issues. So I'm hoping adverse possession is going to get addressed on the remand by the trial court.
So can adverse possession then apply to mineral interests?
Yes and no. And that's a really good question, because that one comes up also in Kansas. And, of course, what adverse possession is if I have somebody, and usually we think of this with respect to the surface estate. I've got somebody that I know is farming over onto me, but I want to be nice. I don't say anything about it. I know they're over on me. They know they're over on me. And if I let them do that long enough, and in Kansas long enough means 15 years, then they could file what's known as a quiet title action and actually claim legal title to that property that they are adversely possessing. But the key to that, Greg, is that I can see them adversely possessing my property. They're using it. They're growing crops on it. They're grazing cattle on it. They're economically benefiting from it, and I'm sitting back doing nothing. It's different with minerals. And with minerals, what we've got is subsurface that we can't see, and we don't know that somebody's claiming it adversely unless they start drilling and mining it. And that would be the key, Greg, in these situations. So if the adverse possessor of the surface uses or occupies the subsurface minerals, then adverse possession might be possible in that situation. So actual possession of the minerals is key. And then we could dissect that even further if we're talking a royalty interest or if we're talking a working interest, and we can break it down even further, and that's what I do in my article. Maybe we'll get some analysis by the Illinois trial court on the remand in this instance, but that's what I dig into, those finer points. I dig into that in my article on my blog.
And so as we end this, any quick advice for what a mineral, if you're an owner and you've got mineral interest, what they can do to protect themselves from the adverse possession claim?
Yeah, just don't sit on your rights there. Lease the mineral rights to an active company. I think that would be a good approach because it would establish a visible use of the mineral rights that is ongoing. It's these interests that sit there and nobody develops them that could be ripened into an adverse possession claim by someone else who starts using them. So lease them to an active company. I think that's your best approach.
Well, as they say, in two cases like this, it's never a boring time as far as ag law is concerned.
No, and today's tax day, too, so we have that aspect going on also for the non-farm returns that did not use the March 1 deadline, and even some farm returns that didn't use the March 1 deadline. Today's the deadline for that, too. So busy day today.
All right, and if people want more information or would like to read more about that on your blog, what's the best way they can reach that?
washburnlaw.edu/WALTR, and I will also send it over to Rich Llewellyn at K-State to post on the Ag Manager website there.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.